Good afternoon, everyone. Welcome. Thank you so much for being here for the second in our series of webinars exploring some new legislation that was passed this year for Florida that we wanted to share information with our chamber members. My name is Christy Bruner. If I haven't met you yet, I am the Vice President of Advocacy here at the Chamber. Just a reminder that our Chamber is actively involved with public policy issues in our community, and our goal is to always include stakeholders and be representative of what's going on in our community. One way that we are acting on this is to provide valuable information to employers in our city as new legislation has been passed in 2023. This webinar, as I mentioned, is part of a series of communications that our advocacy department has curated, including last month's event featuring Chief Holloway and permitless carry bill, which at the end of this webinar, we will have the QR code available to log into that webinar if you haven't participated yet. Just one more reminder, make sure that you're muted, and please feel free throughout the webinar and presentation. And then also at the end, we will be taking questions, and Andrew will be able to view those questions throughout to be able to change up and add to his webinar presentation as he goes. So we'll go on to our next slide, please. So why did we want to present this webinar? Just wanted to give you a quick overview before we get more in-depth information. This bill expanding E-Verify requirements was signed into law, was Senate Bill 1718, as a lot of you may have known. And we also had a really great blog article published by our summer intern, Sarah, who is on the call today. So please find that on our LinkedIn and on our website. If you haven't seen that bill, it goes into some more depth as well. And it is extending the E-Verify requirements for all private employers with at least 25 employees, which I know is why many of you are here today. So without further ado, I will introduce our speaker today. Andrew McLaughlin assists clients in labor and employment matters. He represents private, public, and nonprofit employers in labor and practices a wide variety of employment matters. He also provides clients with proactive advice regarding their HR practices. So we want to thank Stearns Weaver Miller today as one of our wonderful chamber members, and welcome, Andrew.
Thank you very much. You can go and move on. Another slide. So just before we get started, this is kind of generic information. It's not directed to any individual person. Even if I may answer your questions, it's the facts you give me may not be enough for me to give you a legal opinion. So while I am a lawyer, I am not your lawyer in this presentation. So if you have legal questions, I recommend after the presentation, you consult with your appropriate lawyer. Go ahead. Go ahead. So today, we're going to kind of break this presentation up into three areas. First, I'm going to cover some of the I-9 basics. Then I want to talk a little bit about E-Verify. And then finally, we'll move into the Florida law requirements. And I think I broke the presentation down this way because the topic, while the Florida law is new and E-Verify and I-9s have been around for a long time, this is a really good opportunity for many employers to look at their overall immigration E-Verify practices and I-9 practices and fix any common errors that they may have. So because going forward, because of the Florida law, there are kind of enhanced penalties if you're doing other things wrong. So it's important that you kind of take a holistic approach at your I-9 and employment verification procedures. So starting with kind of the I-9 basics, what is an I-9? Well, the I-9 is the form that you have to get signed when you hire a new employee, where they basically prove to you that they are authorized to work in the United States. And generally, you must complete the I-9 for new hires within 3 days of the date of hire. And the date of hire, this is one that gets confusing, is the date the employee first starts work for pay. So you may hire somebody, particularly if you're hiring somebody out of college, where you may hire somebody today, but they're not going to start work for you until September or even a year from now. But you don't have to do the I-9 until 3 days after, within 3 days of them actually stepping in the office and actually working for you. So to complete an I-9, basically what you do is the employee brings in various documents establishing that they're the employee's identity and that the employee is authorized to work. And if you go on to the next slide, basically as part of this process, you're not allowed to mandate the documents that the employee provides. And the I-9 provides lists of the documents that you can provide. For example, there's list A documents such as a passport. They are both identity and employment authorization. So the employee would only need to show one document. There's other types of documents. List B documents show identity only, such as maybe a driver's license. And then there's list C that show employment authorization only, and those are documents such as a social security card. So you may have, the employee can either give you one list A document or a list B and a list C document, but you can't require the type of document. And as we'll talk later, this is all federal law. This is not impacted by the state law. So the state is not allowed to tell you what type of document, and they in fact do not tell you what type of document you have to require. You can still, the employee can still bring you their choice of forms. Now, when you're going through this is the sample form. You can see all the blanks. It's very important that as you go through it, it's fully completed. But when completing the form, one of the common concerns is, as an employer, you're not expected to be perfect when doing this form. You're expected to completely fill out the form, but recognize that you are not a government agency. You are not an expert in analyzing documents. And so there's a lot of leeway when you're reviewing documents as to whether for you to determine if they're authentic or not. And so when an employer provides you the document, you're really only required that the guidance on that is that you just have to make sure it looks legitimate. It looks reasonably legitimate. So does the Social Security card, does it look like a standard Social Security card? I bet everyone in this audience probably has their own personal Social Security card, and the design of Social Security cards hasn't really changed much. So if an employee presents you something that reasonably looks like what a Social Security card looks like, you're allowed to rely on it. They're really looking for if there's obvious errors, misspellings, typos. Did they spell the state Florida correct on the ID card? Are there the wrong number of digits in the Social Security number? Social Security numbers have 9 digits. So if they present you a 6-digit Social Security number, well, that's obviously wrong. Those are the kinds of things where you would be knowingly employing somebody if you were to accept something that clearly wrong. So as long as the documents are reasonably valid, you're allowed to rely on them. And as I've included this sample of the form you have to complete. You see all these blanks. This is from the Department of Homeland Security's website, and it shows you how you have to fill out every area and how you have to put NAs and how, most importantly, you sign and date all of the blanks. This is the part that I think is the most common issue, is that employers do the important part right. They check the documents, they get the documents, they list the documents on the form, but maybe they forget to date it, maybe they forget to sign it. So it's very important that when you're doing your I-9s, you fill in all these blanks. And if you, in the process of going through all of your I-9s and looking through your old forms, you find out that you weren't doing things properly, you have to be very careful when you correct these forms, because you are not allowed after the fact. You should not just fill in the date a day later. If you have to make changes to these forms, you're supposed to make a note of when you make the change and why you made the change. So for example, if you notice you left a date blank, but you know the date from your calendar or some other source as to when you signed that document, you can add the date today and then make a little note saying, I realized I left it blank and verified from my records the date I actually inspected the form. But you should not edit your forms after the date you view the documents. So moving on to the next slide. What are some of the potential pitfalls? Well, the big one I've mentioned is you cannot require any specific document. And this is where a lot of employers, it's tough, because you see things where they want to require a Social Security card, or they think a Social Security card is best, or they want certain documents. Somebody has an ID card and they're concerned that, why do they have an ID card and not a driver's license? Well, under the laws covering I-9s and the federal law, you're not allowed to require any specific form of document. So as long as the document they provide is valid and not a forgery and on their list, you must accept it. So again, if they have an ID card, there's some people believe ID cards have a higher use of fraud. I'm not sure if that's true or not, but again, if somebody were to present an ID card and it doesn't look fake, then it is a valid form of identification and it would be a valid Group B document. So you have to accept it. The other major pitfall, as I mentioned, is the failure to complete the form. Most employers, we see a lot of forms where, they forgot to sign it or they forgot to date their signature. And so those blanks make the form problematic. There's also issues with re-verification. This is a very touchy issue, and this is a common issue that's, I think, we're going to see a lot more issues with this as the new E-Verify law comes into effect. Under the E-Verifies we'll talk about later, you're only allowed to do the I-9 at once, and you're only allowed to do it at the time of hire unless there's a reason to suspect it's not accurate or that the actual document provided, the work authorization, expires. And what I mean by expire, it's not that your driver's license expires, it's that the actual work authorization expires. So if somebody provides a passport that expires next month, that is a valid document, and that's valid indefinitely. You do not need to go back next month and get them to complete a new I-9 because their passport has expired. However, if somebody gives you a work authorization, for example, a temporary work authorization for 60 days, on the 61st day, you will need to go back and complete section 3 of the I-9 to re-verify because their original authorization to work has expired. So it's not the expiration of the document. Many employers think, well, I have this I-9 and their driver's license expired, so I need to go back and re-verify. And that's not the case. It's only when the actual authorization to work expires. So if the individual presents a document such as a temporary work authorization that is not indefinitely valid for work authorization, then you must go back and re-verify if and when that authorization to work expires. So again, re-verification, though, is a very common, and I think we're going to see a lot more issues with this E-Verify law and re-verification because people will misunderstand, and they may think that it's safer if I'm given the penalties in state law for employing illegal immigrants or individuals who are not authorized to work. A lot of employers are going to think, well, I need to go back and re-verify everything because that'll make me extra safe. That'll be an extra layer of protection. And that's not the case. It's actually creating more problems because now you're violating the federal law and you may not have any additional protection under the Florida laws we'll discuss. So going on to the next slide. Another area that I think is going to become more important is dealing with rehires. When you rehire an individual, you have two options for completing the I-9. Excuse me. So option one, if the individual is rehired within 3 years of their original completion of the Form I-9, you may continue to rely upon their original I-9 and simply complete Section 3 to include the date of rehire. And Section 3 of the I-9 form has detailed instructions, but it's fairly straightforward as to how to complete it. So if you have somebody who who started work 2 years ago for you, they left, they come back, and it's within 3 years of their completion of their original Form I-9, they can just do Section 3, and you do not have to complete a new I-9, nor do you have to use E-Verify for them. And in fact, you're actually precluded from using E-Verify if you use this method. The other option is you can just require that all new hires will complete a new I-9, and then you will have to use E-Verify. And so as we discuss later, it's just something to think about as you're dealing with rehires and how you want to comply with the new Florida law for these new hires. Because one of the important points to remember is that the Florida law or the federal law controls over the Florida law. So to the extent the E-Verify law has a requirement that is inconsistent with Florida law, the requirements under the E-Verify law, under the federal law, would control. So I'm not aware of any direct conflicts, but if there is a conflict, the federal law controls. So in this case, where federal law says you are not allowed to use E-Verify, Florida is precluded from requiring E-Verify. So there's a couple other situations like that, just important to make sure because Florida law does have a savings where that it's not intended to exceed the requirements under E-Verify. So going on to what is E-Verify? So E-Verify is a federal program intended to assist with the employment verification process. Basically, you go to everify.gov and you accept the memorandum of understanding, and you're allowed to electronically submit employee information, and they will run it through several databases to determine if the employee's credentials, the information they provided, matches what's on file with the government. It's designed to determine, they're very clear, it is a tool, it is designed to assist. It does not make the ultimate decision as to whether an individual is in fact authorized to work. And actually, one of the common misperceptions is that E-Verify, you are not precluded from hiring somebody, even if E-Verify cannot match their information or comes back with a non-confirmation. However, there's risks in doing so, but it is not technically illegal. It's just if they are in fact unauthorized to work in the United States, you have a burden. You're more likely to be subject to penalties unless you have a very good reason as to why you thought E-Verify was wrong. So it's just a tool that is designed to help an employer make a decision. It does not actually make a decision. So going to the next slide. One more. So what is the process? So the E-Verify process is basically when the employee completes an I-9, it does not replace the I-9 process. So you'll still have the employee complete the I-9. You'll then submit that information to the E-Verify portal. E-Verify will issue a tentative, if E-Verify comes back with a tentative non-confirmation. So E-Verify will either issue a confirmation saying their information matches and they believe that it's likely the individual is authorized to work, or E-Verify will issue a tentative non-confirmation. And if they issue you the tentative non-confirmation, what happens is the employee has 10 days to notify the employer of their intent to resolve the mismatch. During this 10-day period, the employee is permitted to work. So if the employee, the common situation is if the employee presents documents to you that look valid, and otherwise, in the absence of E-Verify, you would permit that employee to work, you are required to have them start even if E-Verify issues a tentative non-confirmation. However, if the employee does not challenge the decision and does not notify you of their intent to resolve the mismatch within 10 days, at that point, you can make an employment decision to terminate them as you do not believe they are authorized to work. So again, this is a common area of misperception. It's not something that you get a non-confirmation and you do not hire the employee and you do not start the employee. That's not permitted. They have 10 days to start the appeal process. And if they start the appeal process, they're allowed to work throughout that process. So you cannot terminate the individual during the resolution process. That is a violation of federal law and could subject you to damages. So it's very important that if the employee otherwise presents the documents, you must let them start work. So moving on to the next one, after you get the final non-confirmation, so you'll get two basic decisions. One is you'll get a final confirmation or you'll get a final non-confirmation. If you get a final confirmation, then you should let the employee resume work, or the employee should continue to work. There's no reason to doubt their authorization to work. If you receive a final non-confirmation, then you have to determine whether you want to continue to employ the individual. And this is a really tough decision. While the laws for E-Verify do not require you to terminate somebody who has a non-confirmation, it's a very rare situation where we would recommend that you continue to employ that individual. There's because of the state penalties, because of the federal penalties, and the fact that you must report your employment decision to DHS, the Department of Homeland Security. Absent very strong facts as to their authorization to work, it's a very tricky and a very risky proposition to employ somebody after receiving a final non-confirmation. So what are some key points? What can you not do in the E-Verify process? And again, if you violate these, there are significant penalties the Department of Homeland Security can issue. They have a lot of penalties that can be from hundreds to thousands of dollars per violation. So it can get very expensive if you do things wrong very quickly, because most of the penalties are assessed on a per employee basis. So if you do something 100 times wrong, it's the penalty times 100. So what can't you do? Well, employers cannot submit somebody to E-Verify without an offer of employment. So if you're going to use E-Verify, you cannot submit that individual until you give the individual an offer of employment and they complete an I-9. You also cannot submit current employees to E-Verify with limited exceptions. So if you have a current employee, and if you have current employees, or if you say one of the common issues, I think one of the things we expect to happen is you're going to probably have a lot of employees and hopefully none in this room, who are employers who have not signed up for E-Verify. They're not doing E-Verify, and they've hired a few dozen employees already since July 1, and they have not run them through E-Verify. And it's going to be very logical that these employers are going to get nervous and go, oh man, I forgot to register for E-Verify. What do I do? So you know what? I'll just go ahead and do it now and submit the individuals now. Well, once you've completed the I-9 process, you're not allowed to go back and redo E-Verify for the individuals. So once they start work, if you don't run them through E-Verify, you can't retroactively go back and do it. So if you forget to do it now, you can't go do it 60 days later. You also, if you have employees who have a temporary authorization, such as a temporary work permit or work visa, you cannot use E-Verify to recertify after that temporary authorization expires. So if the employee's temporary authorization expires and they come back to you with a new temporary authorization or an extension of their temporary authorization, again, you use Section 3 of the I-9 to recertify, and you do not submit them to E-Verify. So moving on. What is the new Florida law? Well, so what Florida law has done is it's built on its prior law, where I think in 2021, Florida passed laws that required state contractors to use E-Verify. And the new law has basically expanded that requirements to require any employer with more than 25 employees to use E-Verify. And as part of that, kind of the hammer or the stick in the law is that it is amended now that there are new requirements and penalties for knowingly employing unauthorized aliens. And so if any employer of any size employs an unauthorized alien, there are penalties under the law now, and those penalties can be very harsh. The first violation is typically a warning. However, if you have subsequent violations, you can have fines and a suspension of any licenses you may have under Section 120. And Section 120 governs many of your professional licenses. I think it's real estate licenses, a whole host of all different types of licenses. So if you have a state issue license, there's a high probability that under this law, if you violate this law, you could face suspension of those licenses. So essentially the state could put you out of business for 30 to 60 to 90 days, depending on your size and the number of violations. And they can even actually revoke your licenses. So it's a very, very strict penalty. Generally speaking, you will get a warning, but if you have a violation after that warning and you have more than, you have between 1 to 10 unauthorized individuals working for you, you face a suspension of 30 days. If you have 11 to 50, it's probably 60 days. And if you have more than 50 unauthorized individuals, then you have until you could face a possible revocation or longer suspension. So it's just going to depend how big you are. The law has also been amended to provide that employers with public contracts, they face termination of the contract. So if you do have a public contract and you do not follow the E-Verify law, or you employ unauthorized aliens, you could face just termination of your contract, as well as termination, as well as basically a 1-year suspension from any other public contract. So it can be very expensive, as well as the state authorizes the agencies to seek payment of the costs associated with the termination. So if there are unexpected transition costs because of the termination of your contract, maybe they have to pay emergency, higher rates to get somebody to replace the services you were provided, you may be responsible for those added costs. So it could get very expensive very quickly. So what is the requirement? Basically they're requiring that if you have employers with 25 or more employees, they must use E-Verify starting July 1st of 2023. And then you must provide a certification on your reemployment tax filings of compliance with the law. And all the documentation regarding these checks must be retained for 3 years. However, one of the things when I talk about the penalties, moving on to, well, I'll go to the next slide. So if the whole way this dovetails in is that this new E-Verify requirement, if you use E-Verify, it creates a presumption that your employees are authorized to work in the United States. And so therefore, even if you have an unauthorized alien working for you, there's a presumption that it's not knowingly and would not trigger the penalties. So it creates a presumption of compliance. And in some ways, it may be advisable for certain employers, particularly those in high-risk fields. They may find that they want to sign up now as well for E-Verify, even though the statute doesn't require them to do so, because if they do have an unauthorized alien working for them, but they've signed up for E-Verify, there's a low risk of the violation being knowing because of this presumption. So when does this start? Going to the next slide. So the Department of the DOE will issue, it's the DEO will issue notices of potential penalties, including the cure periods. They are going to start issuing the notices for violations occurring after July 1st, 2024. So even though it is a requirement now, it appears there's not any, that the state does not have the ability to issue penalties yet under the law, or will not be issuing penalties. I would be cautious because there are still issues that if you knowingly employ, there are criminal penalties for knowingly employing unauthorized aliens. There's also the contractual requirements with state contracts that are in effect and they're not issued by the DEO. So you would have other penalties. So you're not free and clear right now not to comply, but the loss of licensure, those requirements probably are not going to be in effect until July 1st, 2024. So again, while the law is in effect, it appears the penalties will not start until next year. And typically what's going to happen is that if they find in the prior 24 months that you have failed to comply, then you will have a potential penalty of $1,000 per day until you can provide proof of compliance. So if you have if you are found to be out of compliance, you're going to have a very quick time to either sign up for E-Verify and start running everybody, or getting the documentation together to show that you are in compliance, and they can issue $1,000 a day until you provide that proof. There's also additional monitoring if you are found to fail to comply and put onto a probationary status. So the penalties can be, additional administrative burden as well. Now, if you use employee leasing, it's important to note that you can, by contract, generally speaking, both the leasing company and the employer remain liable for it. You may, by contract, just make the employer and not the leasing company liable, but generally both would be liable. If you have subcontractors and you have government contracts, you are now required to make sure they comply, and you may need to obtain an affidavit of compliance from them if you have government contracts. So another interesting situation to look out for. So I see we have a couple questions, and then I'll take some others. So a couple key points is that, again, I see the question. I was told by our PEO that we had until July 1st, 2024 to comply with E-Verify. And so I think the reason that advice is based on the fact that it appears the penalties are not going to start until July 1st of 2024. So it's not entirely clear what would happen if you don't comply now, but it's something that I would not recommend, because particularly if you do have government contracts, the government contract requirements are in effect, and so that would be a problem. Also, this law only applies, I see a question, if I-9s have been filled out, but no employees have been added to E-Verify, you shouldn't add them retroactively. And that's correct. That's going to be I think that's going to be the #1 mistake we see, is that employers are going to rush out and E-Verify their entire workforce. And that is not correct. That is not what you are supposed to do, nor is that legal. That is actually a violation of law. So what you have to do is, once you sign up for E-Verify, so if you sign up today, you would run everyone. And if it was effective today, sometimes there could be a day or two lag between the sign up and your effective date of your E-Verify. But once you are accepted into the E-Verify program, if you were accepted today into E-Verify, you would run all new hires from today through E-Verify. If you hired somebody on July 11th, they would not be run through E-Verify if you did their I-9. Any other questions or comments? Happy to take other questions. You will see as you go through E-Verify, one of the other important things is that E-Verify does have some notice requirements, some additional notice postings, as well as you have employees that when you get an adverse decision or you get a non-match decision from the E-Verify program, you may have to provide them notices and provide them certain notices and follow up with them on certain items. So there's just a little bit more administrative process with your E-Verify. So we have a question. We have contractors such as outsourced financial firms or IT management firms. Do we have an obligation to make sure that they use E-Verify? If you have a government contract, a state government contract or state agency contract, you would have an obligation to get an affidavit from them. The other issue you run into, though, is that if you are actually a joint employer and you are an employer of those subcontractors, it is potential that they are actually your employees, and you would then, therefore, they're your employees, you would have an obligation under the state law. So if you have arrangements where you have misclassified individuals who are really employees who are classified as independent contractors, this could be another area of liability. So if you have less than 25 employees but have city contracts, those city contracts may trigger the requirement to use E-Verify. It should also be in the contract as a contractual requirement, but you would likely need to use E-Verify and you would need to give a certification. So it's important to check the contract. Same with any state grants, even if you're a nonprofit, but many of those state grants now have included language under the statute to require the use of E-Verify. So if you are already a E-Verify user, but you have not processed all employees from the date forward. So this is where the federal law gets, and the state law can be complicated. Generally speaking, it's a violation of your E-Verify terms of use, but it is not something that you're allowed to retroactively correct. So even though you have signed up for E-Verify, your failure to run everyone through E-Verify is kind of it's a violation, but it's not correctable at this point in time. So you're generally speaking, it's just something you have as a potential liability if you were to be audited. Question about recertifying through employment files. So what's going to happen is on your unemployment and reemployment insurance filings, where you pay your state reemployment taxes to the Department of Economic Opportunity, you're going to have a new box to check to certify that you use E-Verify and that you comply with the law. So expect changes to your payroll tax reporting forms for the state of Florida. For headcounts that fluctuate over or under 25, should the company continue to use E-Verify if headcounts dip under 25 employees? From a practical standpoint, it is difficult to, once you sign the memorandum of understanding with the federal government that you are going to use E-Verify, it is not something that is just, this week I want to be part of E-Verify and next week I want to drop out of the program. It is not something you can just readily flip-flop between. So once you sign up for E-Verify with the federal government, you are saying you will use it for all new hires no matter what your size is. So it's not something, once you sign up, you really have to use it indefinitely. Do we have a time frame from when we get a start date to start the E-Verify? So again, E-Verify is typically done, it must be done at the same time as the I-9. So you're going to get the I-9 within the 3 days of the employee's start of work. So if the employee comes into the office and starts performing services for you on Monday, you have until Wednesday to have the I-9 completed. And that would include your E-Verify. You have 3 days. Can you use E-Verify for background checks and employment verification for a business listing service? It really wouldn't have any function because it just says E-Verify is going to just simply have a confirmation or a non-confirmation. It doesn't provide any information. And again, E-Verify can only be used if you have an offer of employment and the employee is starting work. So you can't, it's not really a valid, its only purpose is a tool to determine work authorization as part of the I-9 process. And that can't be done pre-hire. It has to be done after hire. I think those are all the questions we have.
Questions? You did an amazing job. Thank you so much, Andrew, for all of your information. I know there was a question earlier just regarding does the employer have any obligation to notify the employee of the process as far as the confirmation or non-confirmation?
Correct. So there are additional notice postings. So you will have to have another poster with your employment, with your CAST workers comp poster. You'll have to have another poster for the E-Verify. And then if you do get a non-confirmation, you will have to provide notice to the employee of that non-confirmation. The good news is the E-Verify does have the system itself, when it makes these decisions, it provides a lot of the kind of steps as what to do next.
Wonderful. Last chance for this opportunity for any other questions for our expert. All right. We appreciate you, and we appreciate Stearns Weaver Miller being a great chamber partner and member to help us out with this, navigating this as we go forward. There's been a lot of questions surfacing. Oh, one other question that I know that I had too. Can you clarify with the part-time, full-time, what 25 employees means as far as who needs to take advantage of that?
So I believe that the statute just uses 25 bodies. So there is not it's 25 bodies. And as far as employment verification, anybody who is an employee, you must verify their employment status. So there's not an exception. So in theory, even if you were only hiring somebody for 4 days, if they're a employee, you have to, under federal law, you have to verify their employment status. And then state law would also require it now as well.
That's helpful, especially maybe for temporary or seasonal employment as it happens here in hospitality and things like that. So that's really helpful. Excellent. Well, we will go to the next slide, please. Just as a reminder, like I mentioned, this is part of a webinar series that we did. If you want to get out your phone real quick and click that QR code, but it's also available on our website. We did have a webinar last month with Chief Holloway, and that's the passcode as well. If you need that information in the future, just go ahead and email me. We will have this webinar as well available to view in the future. And if there's anyone else in specifically the contracting, subcontracting, bar, restaurant management, any other industries in particular, Andrew?
I think any of the industries that are kind of where you would expect the state to target, where there's a high probability.
Excellent. So if anybody in your network that's on this call that you think that would benefit from this, we will be able to have that link for you to share. And how else can you get engaged with the chamber? Oh, the passcode. Danielle, we'll get that to you. No worries. We'll get that passcode to you, or if someone wants to drop it in, perfect for that webinar. Other ways to get engaged. We want to know what topics are important to you, what topics are important to your business. So lots of ways to get involved with advocacy, our public policy council meetings, our committee meetings, our task forces on lots of different topics, from education to sustainability to transportation, housing and development. So we want to know not necessarily if you're an expert in those industries, but how those different industries impact your specific business and where your viewpoints. We have our public policy pulse email. If you're not signed up for that, you can do that on stpete.com/advocacy. You can sign up for our newsletter and view our topics and our blogs, as well as a lot of our legislative and public policy updates. And then also we have an advocacy lunch and learn series. We just had a few in the past having to do with our legislative kickoff. We had one dealing with our hurricane trip to Fort Myers for sustainability. We have one in August coming up that will deal with affordable housing pro forma and kind of next steps, what's going on with the city and development. And then also one in September with the topic of DEI. So please stay in touch. Please let us know what is important to you. And we appreciate your attendance today. Thank you so much for joining us.
Thank you.
Thank you.